before the Delhi High Court. Second, we have with us Mr. V.T. Venkatesh, who is the founder of Reachlaw, former state public prosecutor and currently practices at the Karnataka High Court. Thirdly, we have with us Mr. Mihir Desai, who is senior advocate at the Bombay High Court, co-founder of Human Rights Law Network and Indian People's Tribunal. He has wide experience in handling human rights cases and criminal law cases. We also have with us our beloved Vice Principal, Dr. Santosh Jaybhay, who has an experience of teaching almost for 23 years. His expertise lie in contract law, law of torts, partnership, and sale of goods. Further, this session will be moderated by Dr. Nitish Nawsagaray, who is an assistant professor at ILS Law College, Pune, and also a research guide at the SPP. He also has a teaching experience of 19 years. He is the faculty in charge of the criminal law cell at ILS Law College, Pune. Now, I would like all the participants to please mute yourself and put your videos off and leave your questions in the chat box. And I would now like Dr. Nitish Nawsagaray to take over the session.
Thank you so much, Aditi. On behalf of ILS Law College, I welcome you all for a webinar on law of sedition. The idea of this webinar has we have been discussing about various topics of law at various seminars and conferences. And after this COVID-19 scenario, we went on we invented a new platform and we went on online and having webinars. The idea of this webinar is that this year we are commemorating the death centenary of Lokmanya Tilak. Lokmanya Bal Gangadhar Tilak was the first pan-India level leader who had an pan-India appeal, and he is a person who was prosecuted thrice under the sedition law. The law under which great leaders of Indian freedom struggle, Mahatma Gandhi, Maulana Azad, Lokmanya Tilak, and many more were tried on the ground that you don't have an affection towards a British government. And Tilak's trial is important also because after the 1897 trial, the law of sedition was also been amended, and hatred and contempt towards the government was added to it, so that the interpretation given by the judge is justified. Then we have a 1908 trial wherein again he was been prosecuted on the basis of a bomb blast happened in Muzaffarpur, and then you have prosecuting him for something that it is his writing which have been influential, and a postcard was found with him wherein there were 2 books, explosive books were written on it. We find a very parallel which is happening even today. And then we were thought that after a century, we don't move. We are not moving anywhere.
Not explosive books. Books on explosives.
Yeah, books on explosives. Yeah, a postcard on which...
Books on explosives, not explosive books.
Yeah, books on explosives were... the titles of the books on explosives were just found. And we find a very much parallel today. And the state prosecuted him. We will be going to the details of it. But we find that... after coming of the constitution and also the directive fundamental duties one we have, one we say that we cherish the values of freedom struggle. And if that is the case, one of the value of freedom struggle is that we always said that we should do away with such type of draconian law. Where are we now? How are we? Where are we moving? So these are the questions we need to answer. And therefore, this webinar has been organized. I'm happy that we have people who have worked on the area where they have been defending lives of people, of citizens, when in case of sedition, in case of preventive detention laws, they have been taking positions in public life and also in court. Before we start the webinar, I, on behalf of ILS Law College and the Criminal Law Cell, would like to mention here that we pay our homage to Swami Agnives ji. He passed away yesterday. Swami Agnives ji has contributed a lot to bonded laborers and the civil rights movement in India. It is I pay my homage. And now may I request the first speaker today, Nitya Ramakrishnan Madam, to take a view on, she'll be speaking on the Tilak's trial, to put her views on the trial of the Tilak. and then after we'll move further. Thank you so much, madam. Towards you, over to you. Yeah, Nitya, madam, it's over to you.
Can you hear me?
Yeah. Yes, ma'am.
Yes.
First, my deepest homage to a mentor and comrade. The most remarkable thing about Swami Agnives was he was willing to go at any age, anywhere, whether it was in the deep of Chhattisgarh or whether it was Delhi's Jantar Mantar. He was willing to hear, he was willing to be convinced, and he was willing to physically participate. He was willing to live with his religiosity and somebody else's agnosticism. In fact, that really is the spirit with which we should fight for civil liberties. And my deepest homage and my grief I express at the passing, as I said, of a friend and a mentor. I have been asked to draw parallels between the current situation and Tilak's trial. Before I draw parallels, I must mention one disquieting and distinguishing feature between the India of those days and the India of today. Sedition was one section at that point of time, which has subsequently been read down in Kedarnath, as no doubt Mihir and others will tell you, and perhaps you know yourself. Today, many penal, preventive and punitive sections abound, which have made resort to 124A quite unnecessary, and therefore the limitation read in Kedarnath has also become by and large irrelevant. You have the UAPA, which has explicit sections suggesting that even to articulate a view that some place must be either part of India or need not be part of India, or that there is a case to relook at our territories, is today an offense under the UAPA. You have the Chhattisgarh Public Safety Act, you have the Kashmir Public Safety Act. So many statutes abound which criminalize opinion and articulation, that 124A is just, it's just a small dot in the landscape. The other thing is extensive use of sections 153A and 153B. If somebody says that the minorities are in peril, or if an article is written about the dangers of espousing a certain ideology, it's quite likely that immediately in any other part of the country, it may not be where you are living, but somewhere else, an FIR may be lodged under 153A and 153B. So it is not just 124A, but the ideology behind sedition has now proliferated in the form of many penal and punitive and preventive detention sections that we'll have to find other strategies to deal with it. And some of them are in laws where even bail becomes difficult. So the simple and conventional methods adopted in 1897, 1908, and 1916 are no longer parallels, except in a sentimental sense. Tilak was prosecuted thrice. In 1908, in 1897, it was for 2 articles. Can you hear me? I can't even see anybody.
Yes, ma'am, we can hear you.
Yes, ma'am, we can hear you.
In 1897, India had gone through 18 famines in the last 15 or so years. Plus, there had been an epidemic in Maharashtra, and therefore it is not, the parallels are quite clear, because today we're going through a pandemic, and the conduct of officials, the imposition, levy of taxes, and the laws which had been imposed on movement, etc., had caused a lot of grief, and therefore citizen and Tilak had written an article vindicating Shivaji's violence. I mean, we may have two views about Shivaji, but one was he had written extensively criticizing the conduct of officials. Plus, he had written a vindication of Shivaji's killing of Afzal Khan. Independently, an irate mob, which had been driven to desperation by the famines, by the epidemic, and by the sheer insensitivity of the official town, killed a special duty officer. Tilak was subjected to a trial, kind of indicating that his glorification of violence of Shivaji, which had occurred centuries earlier, and his criticism was what had eventually led to violence, which led to the killing of a special duty officer. The argument that what he had written and spoken was a political critique was rejected, and lack of affection for the state or the government was seen as disaffection, and he was sentenced for 18 months. In 1908, following the partition of Bengal, Khudiram Bose and his comrade, thinking that they were British officers, fired at a carriage in which there were two women who died. At that time too, Tilak had written extensively, and the media really came out. So some of these parallels are important. Some of these facts are important when we later try to draw parallels. The media had criticized Tilak for his writing, to say that it is this which has provoked the youth. It was not just the state which was vilifying him, but the mainstream Anglo-Indian media had vilified him and said that this is the kind of writing and this is the kind of thought which leads to a proliferation of violent feelings in society. His argument that the correct translations of what he had written in Marathi were not available was overlooked, plus the fact that two books on explosives, my friend here said explosive books, there's a difference between explosive books and books on explosives. There were two books on explosives which was just found. And he said that he was researching them to write an article. Now, there's nothing wrong with books of by themselves. These two weighed with the court, and he was sentenced to 6 years. In 1916, in revision, a court which rejected many of his arguments, but said that interpreting disaffection as mere absence of affection is incorrect, and that any utterance, before it can be punished, must be seen as a whole. So there is a trajectory. In 1916, it was recognized that to want Swaraj by itself cannot be held to be a criminal goal. Now, this was a colonial government, but in 10 to 20, 25 to 10 years, this understanding achieved into the judiciary, political validation of opinion, and this weighed in favor of Tilak's acquittal. So what are the features of this? One, a remote connection was drawn with violent occurrences in one part of the city, town, or the country, and a political view expressed. So there is discursive violence, a very important point, in fact, written very well in an article by somebody called Simran Agarwal in The Wire is, there is a difference between discursive violence and actual violence. I may ideologically believe in violence, but I may not do anything to anybody. I may say there are circumstances in which somebody has committed an act of political violence. Those circumstances must be understood, which many people have been saying about Naxalism, about other forms of extremism. But to brush them all as extremists, which was what was done with Tilak, at least in the first two trials, is a definite parallel that you find today. in the Bhima Koregaon cases, in the Vinayak Sen case, in the Delhi riots cases. Now what? So how many things are conflated? The fact that somebody is opposing the CAA as an unjust law, the fact that they are commending opposition by a group of people. Now let's assume for a minute the CAA is the best thing that happened to humanity. The fact is that a group of people think that it is not correct, into the streets to protest. Others are in discourse supporting them. Now, all this is conflated into one single unlawful activity or possibly a terrorist activity. And there's no distinction drawn between an opinion, a political critique, and actual violence. The obliteration of the distinction between discursive violence and actual violence is a parallel you see between Tilak and today. Likewise, in the Vinayak Sen case, and as far as the Bhima Koregaon case goes, I'm competent to speak about Gautam Navlakha. I will not speak of anybody else whom I'm not representing. But the mere fact, for instance, that somebody wants to have a defense committee, that is a purely legal process for those who are in prison, maybe for violent deeds, is today seen as being part of that ideology itself. So it is not just expression, but guilt by association, which was latent in Tilak's case, has become explicit today. But in some ways, today's India has gone far beyond what was even perceived in Tilak's time, at least by 1916, to be legitimate or illegitimate. Today, the mere fact that somebody questions a manner of prosecution, a linking of a lot of a thought with the most extreme of acts, i.e. violence, is one thing, which was also found in Tilak's time. But that a purely non-violent activity like Chapka Jam must be quoted in order after order to deny bail as saying this is disruptive and therefore UAPA is valid, is a feature perhaps that at least in the pure sedition cases in Tilak's time was not apparent. So I must sum up now because I would rather have questions than argue, than going on talking. So I say that the similar features is a certain intolerance of opposition, yes. The fact that perfectly legitimate explanations can be found for literature is obliterated and is seen only as being significant of the most extreme of acts. And discursive violence, such as was in Tilak's case, is seen as actual violence, or at least, and in fact, in Tilak's case, there was at least a remote link between some act of violence, which is not always there. The Delhi riots, maybe they're saying all these, but in so many cases, people are picked up under the UAPA, under the Public Safety Act, held preventively, without even mentioning that there was any act of violence. Nevertheless, there is a difference, and also the media, the role of the media. Here today in Delhi, even when there is no arrest of a certain person, there is a section of the media which is leaking all kinds of police stories to say why so-and-so not arrested. So there is that role. That is similar, but as I said, the sheer proliferation, the number of laws today, which in fact mirror 124A with much more dire consequences without even the option of bail in the normal course, is one feature. It may have been there in terms of the DIR, etc., even at that time, but today these are mainstream weapons with the state as one. And two, in this conflation of, it is not merely discursive violence, but even mere association for legal aid, which is considered part of extremist activity under these laws, are perhaps features which show that the current day Indian state ideology, institutional ideology, has become perhaps even less tolerant than a colonial system. Are thoughts which I want to leave with you. And before I conclude, I just want to say that when we fight, because the point about Gandhi, which is where he differed with Tilak, was he said the means are as important as the end. So if we believe in that, the point is, if it is expression we want to protect, then that expression does not necessarily have to be to our liking. So the continued use of 153A and 153B, if you are looking at it from the point of view of free speech, you can't just concentrate on 124A. Even in the context of Tilak, you'll have to look at the nuances. There may be expressions, pure expressions without leading to violence, of which we are intolerant. But would we support the use of those sections is a question for introspection that we need even today. When people like us feel beleaguered, we feel that there is a hostile state which is criminalizing dissent. Indeed it is. The Delhi riots cases, the Bhima Koregaon case, innumerable cases before, Binayak Sen before it, UCL documents found in his house. A report on the Salwa Judo, which the Supreme Court has held to be illegal. All this was the basis of not only the sedition charges against him, but the PSA charges against him. The Chhattisgarh Public Safety Act, I think, charges against him. But we have to also ask ourselves, if we say that expression, pure association, must not be criminalized, and that interpretation even to the UAP, even if you want to strictly interpret it, it is only that association which furthers terrorist activity, which is penal even under the UAPA, which I oppose, but even as it stands. But today, people who have formed committees for legal aid are being called Maoists, suspected Maoists, and being thrown into jail. And the amendments of the UAPA are even worse. So we have to, if we have to fight this ideologically, we fight it legally, we fight it on the streets, we are under immense pressure, yes. But to fight it ideologically, I would want to leave with this question, whether 153A, 153B, the obscenity section, whether criminalizing expression for its own sake, without there being an imminence of violent activity, which was the Kedarnath principle, which is getting diluted with all these laws. Whether we are willing to reconsider their use, even against those who are ideologically not with us, is a question, I think, which is worth pondering over for academics and for lawyers. Thank you very much. I hope I've not overshot my time.
Yeah, thank you so much, madam. You have raised some very important issues, and definitely after the presentation of our other three speakers, will be taking up the discussion and question answers. Now, may I request BT Venkatesh sir to put up his views. Over to you, sir.
So very good evening. Today is a day we have to pay condolences and homage to Swami Agnives, a dear friend for millions in this country, indefatigable human rights activist, one who was there. In fact, I've seen him not just at big public functions, even in small gatherings, listening to even a complaint of tribal, a complaint of a destitute woman, a complaint of a woman who is in facing situation. He would listen, he would call, he would try to see. In fact, few days ago, he called me and before his admission regarding what was happening in certain cases. I don't know, the kind of compassion, unlimited, that spoke Swami Agnives. And it spoke that he was one who stood for real values. If I talk in terms of constitutional morality, he was the personification of the same. One could see that. That's something which is the case. Today we miss him really a lot. It's a great loss to this nation, a great loss to the kind of values which we all believe in, because we have lost a very, very dear friend. Today, coming to this particular subject, which is also a subject which was fighting for, had asked me to do, is that the construct of sedition, in fact, taking cue from what Nitya has said, constructs of sedition, it starts from the very concept of treason. When the state became powerful, it starts with blasphemy, when the religion was running the show in the Western Europe. So we have the suffocating laws which existed, which has been used. Because any of the statement, which when you look at any of the history, it talks in terms of that you cannot raise a dissent as against the state or the authorities concerned, and that it flows from that construct. And it has seen changes over a period of time. The way the blasphemy became treason, and as we post 18th and 19th century, the kind of change that took place in Western Europe, the kind of change that came, the kind of movement that happened, the kind of relationship changed, production relations changed, and the way the democracies came to be established. So the new methods were found by the authority. There is something which is always the way the moment you talk in terms of a state and authority, you're talking in terms of protecting itself from any kind of criticism. I think that's something we should be in a position to understand. So you look from the history, whether it's French Revolution, post-French Revolution, and every kind of movement that has taken place in the Western Europe, we have seen that new names coming up for a particular law. Sedition was one which came into existence that way. The disaffection to the state, as we have it here in India, was something which is existing elsewhere too. So only one was distinguished over a period of time because the kind of political movements, struggles that had taken place in the Western Europe, it changed that, yes, we will have a differentiation. Differentiation in the sense that, yes, this law cannot be applicable to us, the masters. This law is applicable to subjects. In fact, it's very, very interesting cases in the appeal cases which we have, long list of them. It takes a long time for me to explain on that, but certainly this is the construct. When you look at this, there is some symbiotic relationship with three aspects. One is defamation, second, sedition, and third, treason. So you look at this construct, you have the kind of defamation, a contempt of court, by mistake. In fact, contempt of court, sedition, and defamation. All talk in terms of the similar kind of terminology, degree of aggravation here, a degree of aggravation there. If it's contempt of court, it's regarding questioning the authority of the court. If it is state that's involved, it's the sedition, and if it's the individual, it's the defamation. I don't see much difference in this construct. If you were to look into the structures of this particular law is concerned, you see that. These are the laws which have been, in fact, Nitya has already made a statement, colonial legacy that we had. In fact, we will construct of defamation, we look into the Indian Penal Code, or the construction of sedition which was there, or the construction of contempt of court that was existing in 1926 Act. That these laws came into existence to protect the institutions of the colonial masters. They needed it because perpetuation of authority cannot happen unless there is a law which enables that process. Now, this was utilized by them to the hilt. In fact, if we were to look into the history of freedom struggle, the history of freedom struggle is replete with the prosecution of sedition. In fact, that can be the wonderful yardsticks to say that, yeah, was he a real serious big leader in the freedom movement? Yeah, how many sedition cases he had would be the yardstick which we had. In fact, in Karnataka, the intolerance was such degree. In Karnataka, we had a poet by name Gnanpith Award winner, Dattatreya Ramchandra Bendre. He wrote a poem in 1932, which said that the state and its authority are suffocating lives of the people. It is time that people say no to it. In a very, very mild, simple terms, but it was very clear. This poem, one poem. He was found guilty of sedition. He was found guilty of sedition and he was taken to a civil prison for a period of 6 months. We had an advantage that he came with a very good anthology of poetry, which is really one of the most respected anthology, it's highly regarded anthology of Dattatreya Ramchandra Bendre. That's something which is important. But the thing is that intolerance was something which was existing because it was the need of the colonial masters to ensure that the subjects comply, subjects follow. Now, when we look into this construct of subjects follow, where are we today? When we have this concept, in fact, when we look into, Mihir is here to talk in terms of Kedarnath. I would not like to delve into it. But certainly I would like to present a fact that what exactly necessity of these laws. If you look at the construct of these laws are concerned, these laws have ceased to exist in the developed part of the world. England has done away with defamation. It has done away with sedition. It has done away with contempt. Why? That in a free society, in a society where citizens have freedom of expression, there is no room or space for it. In fact, the McLeod case of 1899 on contempt of court very clearly makes a statement. The appeals case in Privy Council made a statement that there is no space for contempt. There is nothing called scandalizing court cannot be an offense in the empire. It is certainly an offense in the colonies. Why it is supposed to be an offense in the colonies, scandalizing court? Because we need to ensure that the subjects comply with the law. Subjects respect our institutions which we have created. So the very construct of contempt, or very construct of sedition, very construct of defamation, many of these aspects were the tools which they used for subjects. Now, do we have a place of that nature post-independence when we have such a constitution which ensures that we have freedom of expression? Albeit, however qualified the freedom is, can it be reduced to such a degree that we have a situation that 74 years after independence, we even as on this day talk the construct of a subject rather than a citizen. If I say that contempt of court, if the statement, for example, we had the recent case of Prashant Bhushan, the statements, tweets that were sent, umpteen number, the great number of such messages have been sent, criticisms have been made on this institution, and Supreme Court itself has many a time come over and said this. And we have a whole body of laws related judgments which have come into the court which would be diametrically opposite to the previous judgment. We do have that. So when we look into this construct, we see that the authority which wants to control a particular mode of expression does not tolerate any criticism of this nature. In fact, if you were to look into the tweets of Prashant Bhushan, there is absolutely so civil in its expression. So civil in its expression. There is absolutely nothing which is denigrating the institution per se, except making a statement that yes, I am concerned with the way the functioning was. Why I am taking this particular aspect of contempt was that any statement of such nature is also sedition under the law. Now, for example, we have cases. When we talk in terms of sedition, we see only set of cases. I have been conducting cases. In fact, we had given a series of lectures in JAM and other places way back in 2010, 11. As it was 9, 10, 11. We had a series of cases, lectures on guilt by association. I had an opportunity to express post the British explosion of Kafil Ahmad by the airport, Gatwick Airport. So when we had this kind of cases, a doctor was arrested in Australia. All that he had given some loan to this accused, that he had a SIM card of this accused, which had given a SIM card for use. Beyond that, nothing else. He was incarcerated in Australia. The brother was incarcerated in England. But within 1 year, 10 months' time, he was let go. So when the system is robust, there is a possibility of a negotiating kind of situation. That did not happen in great number of cases. In fact, I have been conducting cases in more than a decade and a half now on these cases of Unlawful Activities Prevention Act, Sedition. 124 is a common cases in any act of cases which alleged terrorism, cases of alleged terrorism. We come across, in fact, we had a case wherein a person who can hardly read and write was presented by the prosecution as someone who is a publisher of Lashkar-e-Taiba. You can't imagine the way the law is put across, the kind of charges that come into. In fact, any practicing lawyer would know, and he has practiced on these cases, will know how this charge sheet come into play, how these investigations have taken place, the kind of nature of evidence. One should read Amitabh Kumar's Evidence of Suspicion. It makes very, very interesting reading on this. He has done a great study on that. In fact, in one case, I had given a copy of that book also to the judge to read, to understand that what exactly is happening in my case too is the same as has been referred to. And this is something which is in existence. The whole construct of sedition does not find place in a free society. It can't find place in free society. Reading down of Kedarnath, I think it's high time that we need to do away with this particular law. It's high time that we do away with the law of defamation, do away with contempt. There's a need, because in a free society, a society and a place where we are citizens, we can't be relegated to the condition of a subject even as of now, despite 74 years of independence. I think that's something which we should think in terms of. That these laws have their origin in states' need for control, states' need for subjugation, states' need for its authority to protect, and states' need to silence any kind of dissent. I think that we are seeing it every day here. In fact, whether it is Bhima Koregaon case or the umpteen number. In fact, I had recently had an opportunity of talking to Senior Counsel Rashmi Katyayan from Jharkhand. He was referring to a case that we had a person who had questioned the Chief Justice regarding acquisition of land for National Law School in Ranchi. She was sentenced for 2 months for contempt of court. She suffered imprisonment. And today we have situations of this nature in India. This law of sedition has no place to exist for first reason. And look at the way it is employed. I would like to use a couple of examples which have been recent of recent. Karnataka has been notorious for these cases in last year. Where I had to run around the length and breadth of the state conducting these cases. From Bidar in the northern tip of the state to Mysore in the deep south, to Hubli and to Bangalore. In all places, we found cases of sedition being employed as against whom? Against a woman who works as a house help, unlettered. She was prosecuted for sedition because her child had participated in a play where the child had made a statement as against the CIA. That was the thing. The mother was prosecuted and she was sent to jail. A poet recited a poem in a poet's meet. He was arrested and sent behind bars. 3 students, Kashmiri students, who were in their hostel room, were singing along to a song sung by a Delhi artist said to have been performed in Lahore, which talks in terms of Pakistan Zindabad. In the sense that that song has been used in all places. It's like any other Bella Ciao kind of thing. But these 3 students had no clue. Making the statement would make them that they will be there for nearly 4 months of imprisonment. 3 months of imprisonment. More than 100 days they spent in prison. So is the case of the student in Bangalore, Amulya. She spent more than 4 months in prison. So is the case of another girl in Mysore. All that the crime she did was she held a poster that Kashmir should be free. So when we have these cases, in all these cases, sedition has been employed. And sedition is used in various ways. Nitya was very clear in statement. It's not just 124A, it's 153A, 153B, 295A, 505 Part 2B. So you have the proliferation of laws over a period of time, including Unlawful Activities Prevention Act, which is one of the haziest, and it can implicate anyone, everyone. Just it's question of the investigating officer need to say that, yes, I make this statement. That is the sufficient information. Not a word more than that is required to prosecute a person for that offense. We see this kind of situation which there is a need for a debate on this subject. We have been talking on this, whether Nitya, Mihir, anyone, me or anyone, the millions of lawyers have been talking on this case because we have been seeing this. The gross abuse of laws. In fact, if you were to look into the yardstick of Kedarnath, none of these cases stand. But still, we are looking into cases of this nature that we are continuing to being prosecuted. And it's every day. There is a proliferation of cases, an implication of people remotely connected to the association. In fact, where this guilt by association is something which is now was a rarity a decade ago. Now it's become everyday situation. And that is something which we see as practicing lawyers. We come across these cases day in and day out. All that is required is that one need to know the other person or that he was an acquaintance, a communication, a message, a letter, a tweet in support. Anything can land the person in trouble. And that's the kind of situation we have landed to. The sedition as a subject has a very colonial background to it. It comes from the very construct of blasphemy, it comes from the construct of treason, and it continues to exist even as on this day. The state seemed to be in the same state of mind as it was even as on this day. I think that's something which is a concern for everybody. I would rather stop there at this and see that how we can take this forward. Thank you very much. Sure.
Thank you, Venkatesh, sir. We should realize that we are citizens and not subjects. That is the whole part of the whole discourse. That citizens should also realize that we are no more subjects. We are citizens of a republic nation. Now, may I request Mihir Desai, sir, to put up his views. Over to you, Mihir, sir.
Thank you very much. Thank you for inviting me here. Part of my work has already been done by Nitya as well as BT Venkatesh, and so that in a sense kind of eases my task. But before I begin, I just wanted to share the grief which they shared about the passing away of Swami Agnives, with whom one had been in contact with since last many decades, and one had seen him doing pioneering work, not just about bonded labors, for which he's been known all over, but also on various other issues of human rights, and more particularly on the issues concerning secularism. He became a kind of a face of secularism in India because of being a devout Hindu and Arya Samajas, being a Swami. He used to always talk about the state being secular. That was something which I think is very crucial as far as the present day India is concerned. Coming to the topic, I will be talking mainly about Kedarnath's judgment of the Supreme Court and its fallout subsequently. But before I do that, before I go into Kedarnath, I think a little background is needed in order to appreciate what Kedarnath tried to do. As Nitya has already explained, and even Venkatesh talked about, before independence, you had a series of cases in which a number of leaders of the national movement were prosecuted, and most of them convicted under the law of sedition, that is 124A of the Indian Penal Code. In fact, Gandhi, during his trial in 1922, when he was charged with having published certain articles in Young India, told the judge two things which are very important. One, he said, is this is a prince amongst the repressive laws of this government. This particular law of sedition is a prince amongst the repressive laws of this government. And he also, of course, said that, look, if the interpretation of this law is that I must have affection for this government, I'm sorry, I can never have affection for this government. So don't expect me to abide by this law. And I will cheerfully submit to the maximum punishment which you may want to give to me. This is what Gandhi said in 1922. Portion of which was repeated by Prashant in the case which was recently heard. Now, because a number of nationalist leaders were prosecuted under sedition, and they had come to a conclusion through their own experience that sedition is essentially a law used to repress dissent. When the Constituent Assembly debates were going on, initially there was a provision in the draft fundamental right of 1902, which was at that time Article 13, which in the provision of restrictions to the fundamental right of freedom of speech and expression mentioned sedition as also a restriction to the fundamental right of speech and expression in the Constitution. But there were a lot of protests against this, and sedition was dropped from the restrictions which can be imposed on fundamental right of speech and expression. Now, Constituent Assembly was not really concerned with individual laws, because so they could not obviously repeal sedition. That was not their task. That was not their job. But the Constituent Assembly in the Constitution comes out with Article 13(2), which says that any law, pre-existing law, which is in violation of the Fundamental Rights chapter, will cease to have effect. Okay? And so ordinarily, the law of sedition should have ceased to operate once the Constitution came into being. Constituent Assembly had applied its mind to it. Of course, it didn't go individually into that particular section for the simple reason they could not. But Article 13(2) made it very clear that it could have been overruled. It was not, but it continued on the penal code. It was not repealed. In fact, in 1951, when two of the first cases which came up in Supreme Court concerning Article 19 dealing with freedom of speech and expression and various other liberties, that is Romesh Thapar's case and Brijbhushan's case. These two cases dealt with the question of banning of certain newspapers. One in Tamil Nadu, one in Delhi, Punjab, which cases were then taken to the Supreme Court. And Supreme Court struck down the ban by holding that the only restriction which can be made on freedom of speech and expression as far as the state is concerned is if it undermines the security of the state, or a tendency of undermining the security of the state. In that judgment, in both Brijbhushan as well as Romesh Thapar's case, the Supreme Court in fact discusses the sedition provision. Okay. Though that provision was not before it, the challenge in those cases was not the sedition provision, but they discussed this provision and effectively come to a conclusion that this provision is unconstitutional. Okay, effectively. They don't actually strike it down because that was not an issue before it. In the dissent, Justice Fazal Ali, of course, disagrees, but the majority comes to the decision, comes to a conclusion. It's an arbiter. It's not something binding on anybody, but it's a conclusion of the Constitution. Sedition should be done away with, or it's an unconstitutional law. After that, the First Amendment comes to the Constitution.
I think, Mr. Kamble, please switch off your mic. Kamble, Ravindra Kumar Kamble, please switch off your mic.
Mr. Kamble, please
Should I
switch
continue
the mic.
or,
Yeah, just 1 second. Can you just, yeah.
Please stop.
Yeah, yes.
This normally happens in all webinars at least once during the webinar, so it's something to be. One gets used to this. Okay. So anyway, so after that, the First Amendment to the Constitution comes in, which prescribes what is known as the reasonable restrictions, and it expands the restrictions not just to security of state and defamation, contempt, etc., but also to public order. That is, so after Romesh Thapar and this thing, Brijbhushan's case, the First Amendment to the Constitution is brought in, which also brings in various other aspects concerning reservation, etc. We are not concerned with that. We are concerned with this aspect of First Amendment, which talks about public order as being one of the grounds on which a reasonable restriction can be placed on the fundamental right of freedom of speech and expression. Okay, in the interest of public order, that's what it says. Subsequent to that, there are three cases which go to the Supreme Court, go to different high courts. I'm sorry. One case to the Punjab and Haryana High Court, one case to the Patna Court, and the third to the Allahabad High Court. Punjab and Haryana High Court strikes down sedition as being unconstitutional. Around 57, it strikes down sedition as being unconstitutional on the basis that it's overbroad, that it's too vague, that the definition of sedition, disaffection, causing hatred, etc., is too vague. Okay, and you cannot have this kind of a vague provision. Okay, which really, I mean, what do you mean by exciting disaffection? If I talk to my wife against the state, also that might excite disaffection in her towards the state. Does it mean I am guilty of sedition? So it is so vaguely termed, the whole section, whole section, that the Punjab and Haryana High Court strikes it down. Okay. Patna High Court, on the other hand, upholds it. Okay. Matter also goes to the Allahabad High Court, where a full bench of the Allahabad High Court strikes it down, saying that this is too overbroad. This kind of in a democracy, this kind of a section has no. I mean, it cannot stand. It can have no validity, and it is in violation of Article 19(1), and so Allahabad High Court strikes it down. The matters reach the Supreme Court. That is Kedarnath's case. Okay, Kedarnath versus State of Bihar, which is, and also there is another State of UP versus Imran. These are two appeals which are heard together by the Supreme Court. Okay. And in Kedarnath's case, the Constitutional Bench of Supreme Court, headed by Justice Sinha, holds that while a plain reading of this section, okay, tends to a situation whereby it can be struck down, it looks like unconstitutional. One needs to read down the section, read down this particular section, so that it can be constitutionally upheld. Okay. This is a scheme which many of the law students would know, that many times, in order to uphold constitutionality of a section, Okay. The courts resort to a practice called reading down a provisions. So they dilute the provisions' actual impact in order to treat it as constitutional. Now, this is what Supreme Court does. Supreme Court also goes into the history of sedition law from 15th century, 16th century, as far as England is concerned, and saying that England has said upheld this law. In England, it's still the law. Okay. In UK, it's still the law. And they've had 400 years of experience of doing so. So why should we strike it down? Of course, if the Supreme Court was to hear it today, they would not have that ground, because in 2009 in UK it has been this law has been repealed. Okay, but in 1962 it had not been. So that was one of the arguments in the discussion which was used. What the Supreme Court says ultimately is that not every disaffection and hatred, okay, can be classified as sedition for which somebody can be prosecuted, but only that disaffection which has a tendency of causing public disorder, okay, or a tendency of somehow acting against the interest of the state, okay. It is only that kind of speech or that kind of communication which can be classified as sedition. So sedition becomes linked not just to speech per se, but speech which is likely to lead to disorder, public disorder. Okay, so violence, okay, comes into play here, which was not the case earlier. Okay, so Supreme Court upholds the validity of this article by bringing in violence. But there are two problems with this whole approach of the Supreme Court. Okay, first problem is that by the time Supreme Court came up with Kedarnath's judgment, okay, there was already another judgment of the Supreme Court in Ram Manohar Lohiya's case. Ram Manohar Lohiya's case, the Supreme Court had already had that when that was nothing to do with sedition, it was to do with public order. How do you, when do you say that public order is violated in order to decide whether an act is constitutional or not? And then the Supreme Court said that there has to be a proximate relation to the violence. So there has to be a particular speech, a particular action has to have a proximate relation to public disorder. It can't be just a general tendency of public disorder. Okay. Now, Supreme Court in Kedarnath does not make that distinction. So in Kedarnath, what happens is that the relationship between my speech and public disorder need not be proximate, need not be imminent, need not be immediate. It can be just a general tendency which may lead to public disorder, may not lead to public disorder. That kind of a interpretation which has been given by the Supreme Court in Kedarnath's case. The second problem which I feel with Kedarnath's judgment, okay, of the Supreme Court, is that if you are really testing, because you see the First Amendment which I talked about bringing in for the first time public order as one of the exceptions to freedom of speech and expression, also brought in for the first time in Article 19(2) the phrase reasonable restriction. Earlier, the phrase was restrictions on the basis of defamation, etc., etc. But now the phrase was reasonable restriction. So it is not enough to have it is not enough to justify a law by showing that it restricts on the grounds of public order, but it further needs to be justified by saying that it's a reasonable restriction. It's not just any restriction, but a reasonable restriction. Now, it was never tested on the ground of reasonable restriction, okay, in Kedarnath's case. So that's the other problem. I personally feel that if you test it on the basis of reasonable restriction, okay, sedition today, okay, it would have to be struck down. There is no way it can be held to be valid. There is a third problem. Okay, this is a third problem which actually I faced when I was handling this case of Asim Trivedi, who is a cartoonist and who had drawn some cartoons about corruption, about various other high-handedness of the government, had drawn only cartoons. he was charged with sedition, put behind bars. Okay. When the case came up, of course, it came up in High Court for his bail. And during the discussion of bail, of course, he was released on bail immediately after that by the High Court. But the point is that the question came up that how do you, what kind of guidelines should be issued to the, because we showed that there have been a number of violations of, number of people have been arrested under the sedition law, okay, for some very, very minor kind of things. So the misuse of the law was rampant. That's what we were able to show. And the question was that how do you stop this misuse of, law? So the court asked us that give us some guidelines which we can ask the police to follow. Now, one of the things was about violence, okay, because the High Court could not have struck down the provision because Supreme Court had upheld it. So High Court had no authority of striking down the provision. It had to maneuver within section 124A. So what the High Court said that, what we had suggested to the High Court is this violence bit is a little problem, because what Supreme Court says is that if it leads to violence, it can be sedition. Now, violence against whom? Asim Trivedi draws a cartoon. 5 stones are thrown at his house. Asim Trivedi is beaten up. Okay. He then is charged with sedition because his cartoons led to violence. The argument which we were making, and which I think is a very sustainable argument, is that sedition is under the chapter of offenses against the state. So the violence which you are talking about can only be violence against the state. I write something, you beat me up, and because you beat me up, you say it is violence, and therefore you charge me with sedition, is a ridiculous kind of an interpretation to give to sedition, to violence. Okay. So, of course, the High Court then gave certain directions as to how, as to only a superintendent of police can sanction this without a written opinion, a legal opinion. You can't charge anybody with sedition, etc. That was a order given by the High Court. Unfortunately, in 2017, when a similar matter went to Supreme Court in the case of common cause, the Supreme Court said that no, we don't want to give any directives. We are just telling everybody to comply with Kedarnath's decision. That was a decision given in 2017 by the Supreme Court. So the directions given by the Bombay High Court really became superseded by the Supreme Court. So today the situation is, because that is the last thing which I wanted to speak about, is that, you see, somehow we have come to the conclusion, that our courts have come to the conclusion that while deciding the constitutionality of a law, we will not look at its misuse. Okay. Now, according to me, this is a wrong approach to a law. If a law is rampantly being misused, and if people are able to show that this law is being rampantly misused, okay, which means what? Which means Article 21 of people is being violated, 19 is being violated, 14 is being violated. Okay. Then it should be treated as unconstitutional, provided the misuse is established significantly and substantially. And this is something which you can do easily in a case like sedition, where 3,000 people are charged with sedition because they oppose peacefully a nuclear plant. You oppose peacefully a nuclear plant, you are charged with sedition. You write something on Facebook, you are charged with sedition. You write something on any social media platform, you are charged with sedition. So sedition has become a handle to crush dissent, and that is why its misuse has become so widespread that no amount of diluting it or no amount of reading it down will really help anybody. It is true that for taking cognizance, you need the state government's permission for sedition. If you want to charge anybody with sedition, you need the state government's permission for taking, before the court takes cognizance. But the cognizance state comes only at the time of charge sheet. So arrest can be made without the state government's permission. A person can be behind bars for 6 months without the state government's permission. State government's permission, the cognizance comes only at the time of charge sheet. So that really doesn't help. It doesn't protect people from misuse of sedition law. And the misuse is really rampant. And that is the reason why I feel that, apart from other reasons like freedom of speech and expression, etc., and public order and all that, I feel that sedition law, and England also has done away with it, Australia has done away with it, a number of countries have done away with it, which had it earlier. And the same offenses, okay, which are like violence, etc., violence against the state, violence against people, are already punishable under various other sections of the Indian Penal Code. Okay, I can understand if there was something which was not punishable elsewhere, and that's why you have the provision of sedition. You have the waging of war against the state. You have 153A. You have generally, a whole series of offenses against the body, such as offenses against the property, which are already criminalized under the Indian Penal Code. You don't need this special law for which the punishment is life. The maximum punishment is life for sedition. Just imagine that situation. You don't need that kind of a law. And therefore, I personally believe that this law, it is high time that we do away with this law. Thank you very much.
Thank you so much, sir. It's high time we do away with this law, and thank you for putting Kedarnath in context. Now, may I request Santosh Jaybhay sir to put up his views. Over to you, Santosh sir.
Good evening to all of you. How the Mihir sir had mentioned that many of the speaker had spoken so much about sedition and then respective cases. Before I begin with this topic, I would pay my deepest homage to Swami Agnives, and then I'll begin the discussion. When I had gone through the topic a few months back, and I thought that the initial thing which came up in my mind, that our government cannot do anything against our own people. I'm making this statement before Koregaon Bhima episode. And I thought that being a student of law and a teacher for law of contract, I had an interest to read section 124A. After reading section 124A, my interest has developed much of the definition which is explained by Mihir sir. But one thing which I would like to mention over here, and that is a disaffection, and top of it, after committing of a kind of a statement or making of a statement, look at the effect of the statement. Why I'm telling, because many of them, they are there and students are there. They may not know in detail section 124A, and I would not explain definition, but at least crux of this definition, which has not been highlighted, thought that I should just explain to the student. To see the effect in the public at large. And for this purpose, we need to understand kind of a definition to see the disaffection and disloyalty. These are the words which are used in this definition. But then ultimately, we have to look at the effect after making a statement. That is a big expectation in this particular section 124 in today's era. But initially I thought that I have tried too much to protect government and to speak pro section 124A. But then after going through the case laws, because news items and then the initial actions which is taken by state against, say, for example, Asim Trivedi or any other case, which we know many of the cases nowadays, media is so kind, which is highlighting all those things, either side. But at least I would go by then case laws, which is decided by Supreme Court. And for this purpose, we have to look at section 124A in that perspective is my topic, which I would like to discuss. Especially, I would like to highlight one quotation which is made by Supreme Court in Nazir Khan's versus State of Delhi. Why I have to read it out? Because you can understand what Supreme Court is thinking at that point of time, thought on this particular section 124A. And then Supreme Court held that, and the quotation, line of dividing preaching disaffection towards the government and legitimate political activities in democratic setup is very thin. It cannot be drawn. it cannot be ascertained with precision, and that where legitimate political criticism of government in power ends and disaffection begins. I think everything which has been covered, and how the I would refer all the time Mihir sir, because uh, clashing with some of the issues which is discussed by Mihir sir, I thought that to just extend his speech and to put it to, or to rather add something which is spoken by him. Uh, he had given an illustration. If he make any statement against, or rather kind of a statement before his wife, and then look at the consequences of this statement, and then can we apply section 124A? I would say it is not required to be then make so much of space for 124A, but if you look at some of the case laws, and which are quite interesting, and I would just put it in one line fact, especially in respect of Barbil Singh versus state of UP in 2000. People were listening the music, and along with this some cassettes and some speeches of seditious nature. They were just listening. They did not do anything. They did not utter a word, and they have been charged. And not only they have been charged with section 124A, but they have been charged along with this 124A with section 3 of TADA. And as we know that at one point of time, how TADA was misused along with section 124A. Supreme Court was quite annoyed at that point of time and kept it this kind of a conviction aside, and said that to be more conscious towards applying of section 124, and then top of it applying TADA as well, especially in this Balbir Singh's case. But before that, there were two cases which are required to be discussed for this purpose, and that is also most important. And then at the end, I would discuss Hardik Patel's case. In Balwant Singh's case, Balwant Singh versus State of Punjab in 1995, and then after that, Bilal Ahmed Khan versus State of Andhra Pradesh in 1997. In both the cases, facts are quite, I would say, simple to understand. Only this after assassination of Indira Gandhi, these two government officers who had just made a slogan, raised a slogan, and did not, after this slogan, did not found any kind of effect of their slogan in the people at large. And they have been charged according to section 124A. And I would quote over here what Supreme Court held it. Why? Because this background is required for the purpose of understanding Hardik Patel's case. That is most important. Court felt that, and which is given by Supreme Court, and said that the police official read too much. Police officials read too much into the slogans and exhibited lack of maturity and sensitivity in arresting the two government servants. That is the one expression which is made by Supreme Court in Balwant Singh's case. The second case is again quite interesting for the purpose of just applying of section 124A against appellant. And what he did in Bilal Ahmed Khan's case versus State of Andhra Pradesh in 1997, he was just made a statement, and not in public at large, but with some people. And he shared, because he was a Kashmiri student, and made a statement, said that there is a lot of atrocity committed by army officials in Kashmir. That was the only thing which he uttered. And then after that, he was arrested and he was behind the bar for 6 months. And then when matter went in the Supreme Court, and Supreme Court held it, and then again would like to quote the same thing which is done by them. Supreme Court did not only make comment on the, or rather remark on the action of the police, but Supreme Court made a comment on the verdict which is given by trial court as well. And what Supreme Court said it, especially in this Bilal Ahmed Khan's Kalu's case, court condemned the mechanical order of conviction of citizen in such a section, such a serious offenses and advised that more care should be taken before liberty of a citizen in inferred with. See, while making of a statement by Supreme Court, especially in these matters, and said that this action which they don't appreciate, rather they sometimes condemned, and not only condemned to the action of the police, but condemned to the action which is taken, or rather than order which is passed by trial court. That is something very, I would say, seriously taken note of it, and then accordingly we have to think of this section 124A. Then we would come to the next case, which is a quite interesting one, and that is also Hardik Patel's case. Many of them, they may know that what had happened and what the Hardik Patel, who had uttered specific words in the air of Mr. Desai. One line fact is there. In the case which I'm telling, Mr. Desai, who was an officer, in his air, and he whisper, that is what the alleged fact which is noted in Hardik Patel's case, and killing of 4 to 5 policemen he had mentioned in the air of the Mr. Desai. And a media was then noticing this conversation between these two. That was not a conversation, only dialogue which is made by him, and Desai had just heard it, and that was captured by media. And then after that, complaint which was lodged against them, lodged against Hardik Patel. Hardik Patel initially went in the High Court and then later Supreme Court for quashing of FIR. And here Supreme Court did not then quash the FIR after going through all those cases, and top of it condemned to the trial court's order, especially in Bilal Ahmed Kalu's case, and knowing the entire episode of this applying of section 124A. If a Supreme Court itself passing of an order and referring back matter to the trial court for conducting of a trial, and matter is still pending. My point being to look at the situation, and then we would discuss about either Asim Trivedi, Hardik Patel, or anyone like Nawlakha's case. Take any illustration. Being a law student, or rather than studied in law, one should not get emotional. But then after reading these kind of incidences and after knowing these kind of incidences, I think one must then get emotional, because we are living in the same state. We are following the law, and sometimes in some of the occasion, if something which is spoken by someone in some different purpose, we should take it with the same spirit instead of then. And then, as rightly said by Mihir sir, Article 19(1)(a) is there. Then reasonable restrictions are there. But these people are getting stigmatized. Not only stigmatized, we have to see their time, their career, they're stigmatized in jail. These things we have to take into consideration for the purpose of then applying of section 124A. I am also having of the same opinion, what the opinion which made by all the panelists, that it should be struck down. With these few words, I would stop here. Thank you to the organizer. Thank you.
Thank you, Dr. Jaybhay. We had presentation of all the 4 speakers, and a few important issues has been raised. Nitya madam did spoke about that. If you just look at what happened in 1916, the Tilak's last trial, and if you look at the things now, things are becoming more worst. Apart from sedition law, we do have many more other legislation where you have been branded to be international, and all your freedoms, liberties have been taken away. So state is becoming more and more intolerant day by day. And today we are living in a situation where similar what happened to Bal Gangadhar Tilak. So in similar manner, we will be looking at you have been treated as international for even having a postcard with you. Thank you, Venkatesh sir, that you spoke about the philosophy, and one important distinction you made that these laws are very colonial, these laws are feudal in nature. Now, when we consider ourselves to be a republic, a democratic republic, in that case, do we need to have such type of legislations wherein these legislations were primarily based for subjects. And Mihir sir did put the whole Kedarnath case in context, but he made a very important point. He said that the interpretation itself is problematic. The approach of court is problematic. You can't look at other things saying that how many cases have been misused or how many cases have not been misused. And then in the you spoke about that misuse should not be the parameter of striking down the law. And if the legislation is misused and people are losing their civil liberties, then definitely the custodian of our constitution, custodian of civil liberties, should look into the matter. Some statistics what we have right now with NCRB data, it shows that in last few years, 2014 onwards, NCRB started registering the data regarding offences registered under sedition laws and others. They have again created a category called as international legislations, and then in that case, the number of offences registered is moving high. But we all know that there's no conviction, and how can there be a conviction? Because after all, the court will apply Kedarnath per principle. It has never led to violence, and a person will be acquitted. But what happens? The whole preventive detention laws or the special criminal laws of sedition laws, here in this case, the procedure itself is a punishment. And that is what all the speakers do spoke about. The 6 months you are without bail. Then what happens is the latter part, charge sheet hoga nahi hoga, baat mein baat hai. And that is quite alarming. That is quite alarming. It was asked to the state home minister state that do we plan to do away with sedition law, and Rajya Sabha says that no, rather international activities are increasing, we need to have such type of legislation. People are saying that even criticism of constitution and criticism of the legislature and of the judiciary should also be brought into it. So a very scary situation has been coming up, and therefore I suppose we should address these issues at appropriate time. We have a few questions in the chat box. I suppose all the speakers are here. I don't know why, but Nitya madam is not here again, because she joined and again she left. So
Well,
can we take the questions?
I have not left. You cut me off earlier.
Yeah, no,
by mistake, perhaps.
Yes, yeah.
I'm not so rude as to walk away when my colleagues are speaking.
No. Yes. So yeah, maybe I can see you on the screen. Thank you, ma'am. So yeah. Can we take some questions? Aditi? Yeah. Thank you, madam. Thank you.
Yes, so we have a few questions. So the first question.
And you can take questions together. Yeah.
Yes, sir. So the first question is, instead of a total repeal, would an amendment to include the essential ingredient of incitement to violence be a better option?
I'm sorry.
So the first question is, instead of a total repeal, would an amendment to include the essential ingredient of incitement to violence be a better option?
Okay. So, Mihir, you have to switch on your microphone.
Oh yeah. Huh?
Yeah.
Please.
No, I just feel, you see, I mean, if you go strictly by the Shreya single definition, as I guess most of you know, that in Shreya single case, section 66A of the Information Technology Act was struck down by the Supreme Court about 3 years back. Okay. And it was struck down. It basically criminalized certain social media activities. While striking it down, the Supreme Court made a distinction between discussion, advocacy, and incitement. And the Supreme Court said that while discussion on any issue, no matter how unpopular, can never be a crime. Even advocacy of an issue, which no matter how how unpopular, can never be a crime. It is only when it reaches the stage of incitement can you criminalize it. That's what the Supreme Court says in Shreya Singhal. Now the problem with if you see what has happened just 15 days back or 10 days back, one of the high courts had to come down heavily, saying that even after 66A has been abolished 3 years back, police stations are rampantly filing cases under section 66A against people, against individuals, and arresting them. Okay. Now this is the situation, because I completely, okay, if you like, if you go even for sedition laws, okay, the Supreme Court by itself, like Professor Jaybhay also mentioned, okay, Supreme Court by itself has let off a lot of people, but by the time you reach that stage of letting off by the Supreme Court, you're already in jail and you're already persecuted, etc. So my personal feeling is that incitement leading to violence is already a crime under 153A, 153B, under 505, and even otherwise. Okay? So there is no need for a special provision within sedition or even waging of war. So there is no reason for having a special law, uh, a special carving out of exception in the sedition law, in order to uphold the validity of that law. So I mean, yes, it would be a dilution from the present situation. Yes, whether it will be effective, I have my doubts. And because there are other provisions of law which already protect this kind of violence, which already deter this kind of violence, I would still be very strongly recommending doing away with sedition law. That's how I would look at it.
I have something to say, and I want to say it now, Mihir.
Yes.
I join issue with you. To fall back on other obnoxious provisions like 505 merely because they have a lesser punishment is ideologically problematic. Because if you think that expression should not be criminalized, then you cannot now in sabka hawala deki sedition ko hata ke. See, that is why I said ideologically you must consider whether expression simpliciter should be punished. Then comes the question, which is very pertinent. Incitement to an offense is already part of several offenses. In terms of abetment, in terms of conspiracy, in terms of common intention, in terms of 148. So if you are actually inciting an offense, the concerned violent offense has its attributes. But whether expression, and I'm telling you again and again, concentrating on 124A is being completely apolitical, which lawyers cannot afford to be, particularly if they are pushing for expression. So I'm saying this entire lot of sections which penalize expression for the sake of expression, on the faint count of incitement, have to be done away with or have to be reconsidered. And incitement to any offense, in any way part of it, from attempt to 511 to 307 to 120B to 34. I hope your criminal law teachers have taught you this. So I don't see.
Can I just quickly get into not a debate, but actually I tend to agree with what Nitya said. I have no dispute on that. In fact, just taking from what Nitya was saying earlier, much earlier when you started speaking, today I was having today before this webinar started, I was having a meeting with some of the newly the friends of some of the newly arrested persons under the Bhima Koregaon case. And at that time, they were saying that we don't mind being charged with 124A. That is getting 124A, at least we'll get bail. UAPA, we don't even get bail. So you see, I mean, I have no disagreement. I was only saying in the context, I agree totally that expression by itself can never be criminalized. It's only expression which has an imminent link, a causal link to certain kind of violence. Okay, only that can, if at all, be criminalized. There cannot be a criminalization of expression per se. Okay, so there is no dispute on that. I was responding to the question about incitement to violence. So in that,
that's part of various sections already.
But still, I would like to add just only this part. Only this part. You see, the whole construct which you talk in terms of these offenses are concerned. The people are driven to situations. That's the whole process of when we say that the sedition, the control of the state, the states are not allowing any form of dissent and trying to restrict any form of dissent or any possibility of a debate as against the state. Now, that being the whole construct, it uses these laws. And now the construct is what we have talking in terms of is that people go to a situation where that, that you are behaving yourself as a subject, saying that please, if I am prosecuted for these offenses, in fact, most of us who are practicing on criminal law, we come across this. Agar ye section nahi hota, to acha hota sab. No. So we are driven to a situation, though one has not committed a crime, we are driven to a situation, we are looking at possibility of securing a bail, possibility of letting off with minor punishment. So we are put to a situation. In fact, this happens. While these laws, these kind of cases are more visible in a case of Bhima Koregaon, there are umpteen number of cases of this nature which go through in tribal areas and among the Muslims and across the states. A number of thousands of them are incarcerated under the various laws of the state. And UAPA is now most blatantly employed law. It is a factor. So you are looking at a situation wherein that these people are driven to a situation that you need to request. So the question is that, as Mihir said, that agar ye nahi hota, to hame bail mil jati. One who has not committed a crime, what one has done is not even a semblance attributable to be a crime. He is being prosecuted and he is being incarcerated. He is in a position, he is driven to a situation to come and make such a statement. I think that is the draconian part of it. That is the dangerous part of it. And that's the reason why this kind of law, for example, when Nitya says that the very construct of incitement to violence need to go because there are common offenses which we have, whether it's 34, 120B, you already have those laws. You don't require this particular kind of laws in existence. And admittedly, we had these cases. In fact, there was a speech by Gauri Lankesh. She was slapped with 153A. There are so many cases of this nature. Anyone who speaks, he is liable to be prosecuted if you don't believe in a religion or you have any questions relating to a religion. Mere expression of a question to a religion can also get into 143A, 153B and 295A. So now that's the construct that we have. The incitements which you talk in terms of by nature, I think should not have a place rather than just looking at the framework of 124A. I can't disagree with what Nitya said. I would rather strongly advocate that kind of a thing because we see this happening. Yeah. Thank you.
Yeah, we'll take another question. And there are a few questions in the chat box on the Google Meet also. I suppose you can just combine all the questions and put it. Yep.
Yes, sir. We have another question
Yes,
for
yes.
Nitya ma'am.
Yeah.
While UK has repealed the law on sedition, a first world country like the USA statute still includes sedition with a maximum imprisonment of 20 years. How do you see this in light of the extreme importance given to free speech in the USA?
See, I think the US is a complicated example of many things because there are federal laws, there are non-federal laws, the way they are interpreted, they go back and forth. But I consider these things on first principles. I believe that speech should not be criminalized. There may be civil consequences for certain kinds of speech, like defamation, etc., whether they should be there or not. But to say that deprivation of liberty or a fine or a criminal process is possible for expression, no matter how stupid, you don't all have to be Voltaires. I'll answer in the context of the US. So on first principles, I say if you want a democracy, and forget about whether, let's assume you don't want a democracy. I should have the freedom to say I want a dictatorship. I should have the freedom to say I want a Hindu Rashtra. I should have the freedom to say I want, I want India to become Islamic. Provided that it does not manifest into something violent. If it becomes something violent on the basis of what I'm saying, that is independently an offense. This being my fundamental grund norm, neither the US nor anywhere else affects my judgment. If sedition is an offense, that is this, and I don't see why. Given my understanding of the relationship between the individual and the collective, I believe that the collective should be able to garner respect on its own terms by its provider role, by its primary sector role, by its ability to have broad shoulders, rather than insisting. I'm giving you an example. You can insist that a parent provides for a child. You can insist that a parent does not use corporal punishment. You can insist that a parent is not cruel. Can you force a parent to love a child? Or vice versa? So to say that you must of necessity have affection and loyalty, to me, is the first. I have both a practical objection to it and a principled objection to it. The US or no US, I believe that any commitment to free speech would mean that you do not criminalize speech per se. You must understand that in the US, they recognize freedom of the press as a separate right. The US trajectory on freedom of expression is slightly different from the Indian, and the clear and present danger test, with the all but hinted at in Kedarnath. So there are nuanced differences that would need another, but I'm answering this on first principle. Even assuming that US had a stronger law on sedition than India, I would say that their commitment to free speech is suspect so long as they criminalize speech simpliciter. That remains my answer.
Yes. There are a few questions in the chat box here. I'll just read few of the questions together, and then we can go. One is specifically for Mihir sir. Internet is misused more than it used. Should it be banned? Similarly, the mere fact that provision is being misused makes a case for its removal. Do we need better rules for use instead? So we'll take all the questions together, and then in totality, you can just give an answer. This question was from Mr. Vikram Raje. The other question is Mr. Ajay Jaybhay. If at all there is a demand for holding this section unconstitutional, is it not making the public more intolerant in terms of any action taken by the government, which is stricter in nature in the name of individual liberty? Satyajit Deshmukh has a question. Do you think as sedition law, the breach of privilege motion should be also struck down? Satyajit have some recent incidences in his mind, I suppose. Can a case of sedition be filed on the people in power themselves? Rashmi Raghavan has two questions. I'll read the first one. Should we have a separate category called political prisoners with different privileges? In case this, I ask this because of the constant lack of sympathy shown during bails in Bhima Koregaon or CA incidents. I have ideas of constitutional protest become outdated. Vikram has the same thing about free speech, and he said that I suppose Vikram Raje hasn't. I'll just read the first part. He says that sedition is not required in free society, but the society too has to be matured enough to handle freedom responsibly. Rights come with duties, and that is what the whole flow is about. The whole task. Amol Kale has said that considering the NCRB data, which gives us a clear picture of misuse of Section 124A, and also the fact that political parties like Indian National Congress and CPM have declared in their respective manifesto to abolish this relic of the British period. So what is the way forward? Should this law be scrapped at all, or should there be a holistic amendment again to curb the misuse? This and there are few more questions. I suppose all the speakers, you can decide on what part you want to respond to. I've just taken all the questions together so that in your comment you can decide this.
Can I just respond to two of the questions? I
Yes,
I think just very quickly. See, as far as repeal of 124A is concerned through the Parliament, ideally that's the way it should be done. But I personally don't see it happening in near future, and I don't care which government is in power. Okay, I don't see any government, neither Congress nor BJP. Congress was in power; it could have done it a long time back. Neither Congress nor BJP or NDA or UP or anybody. Okay, repealing. It's one thing having it in your manifesto, another thing actually concretely implementing it. So I don't see that happening through the Parliament, and therefore you go back to the courts. Okay. Looking at, very frankly and very bluntly, looking at the present Supreme Court situation, I don't think I see it happening in Supreme Court also very soon. Okay? So we are left with that kind of a situation today. Okay, but whatever limited possibility is there, I personally feel that limited possibility is in courts, not in the parliament. Okay, that's how I look at it. Okay? Or at least diluting it, or something like that. I mean, in terms of strategically, I mean, ultimately, I agree with what Nitya said, but strategically, you might want to have a situation whereby more and more people are protected, to have some kind of dilution or have some kind of directives, etc. That is more possible through the courts. That's one thing. Second thing, I just wanted to this internet thing. Yes, the internet information technology platforms are being misused quite a lot, undoubtedly, but I would never go for banning of anything. Okay, banning of internet is not really an answer for anything. I was just seeing an excellent documentary on Netflix, actually, on the whole way in which this Netflix, whole way in which Google and Facebook and Twitter and all work and operate. Okay, and it showed how they are trying to control everybody's lives and everybody's minds. Okay, but I would still not go for banning of this. The ban is not an answer. You need a good data protection law. What you need right now is a good data protection law in this country, which we do not have. Okay, so that is something which we don't have. Again, as I said, that I wouldn't go for banning. As far as protests is concerned, this is the last thing which I wanted to respond to. As far as protests are concerned, while we have a fundamental right to peacefully protest under Article 19 itself, yeah, there have been number of restrictions put today and since many years, okay, on our right to protest. For instance, if you go to Delhi, your protest is confined to one Jantar Mantar where nobody else comes but you are talking to each other. Okay. Similarly, if you come to Mumbai, your protests are confined to Azad Maidan, where again nobody else. I mean, the whole idea of protest is to send your voice to the people against whom you are protesting. That's the whole idea. The whole purpose of protest is that. Now, that purpose has been completely done away with this kind of restrictions. Some of them imposed by the courts themselves. Okay, by the High Court or by the Supreme Court. This is one problem. And second thing is, of course, 144 constant, okay, renewal of 144 by which you are not allowed to meet, you are not allowed to gather together, etc. And third thing is criminalizing of protests in various ways, whether by filing cases for unlawful assembly, or using various other sections. So yes, while we do have a fundamental right to protest under our constitution, it is being eroded, and it has been eroded very, very fast over the last many years. Okay? So that is how I would. It's not a happy situation, but we have to protest against this right of protest being done away with. And I think that's something which we have to look at. Thank you.
Just tell us which question we should answer. Political prisoners question, you see, I'm also sorely tempted. I think there should be a class, but the difficulty arises. Nathuram Godse was actuated by politics. Maqbul Butt was actuated by politics. So if an offense is committed, should you have a special class because it is actuated by politics is a question. Then, of course, where offences are not committed, but people are wrongly prosecuted. As, for instance, many in the Bhima Koregaon case or the Delhi Rice case, and that will always be. But the difficulty will be in the actual classification. So when you move out of your own personal predilection to classifying it in legal terms, which will be required, there will be some difficulty. So emotionally, I'm with you. For people with whom I have a sympathy. But as a lawyer, I would say that the manner of classification will be different. Unless you're picked up purely for protest and put away for 15 days, 20 days, 30 days, then I can understand they're there for violating some. But if they are offences which are otherwise serious, as per the law, however unjust, then a classification only because they're actuated by politics, whether it's fair and unfair, is a good question. I don't have a simple answer to it.
One aspect,
if there's any other question attributed to me, you can ask me. Otherwise,
one aspect that underlies in all these set of questions is that our inability to look into the impunity of the state. And that's something which is very, very writ large. Impunity of the state. Absence of accountability to the state mechanism. For example, I was working as a state police prosecutor. When you look into these charge sheets, we inquire with the police officers. How can you come with some kind of charge sheet which is by and large can be seen that it has been written in the police station rather than being investigated? When I asked this question to the officers very clearly said, sir, I have little time for this job. There is some staff in the police station called a writer who writes. He is the scribe of all the charge sheets. Now, it is these charge sheets which are the foundation on the basis of which thousands of people are in prison. I will give you a very interesting example. This requires an example of this nature. I was handling these cases of set of terrorism in state of Karnataka and Andhra Pradesh, trial cases. They had those trials. I found in some 8 cases, some 3 pages of the charge sheet has been cut, copy and paste from a Delhi charge sheet. And it's done. And we have the same set of accused who are cited in Delhi charge sheet as being accused in all these cases as well. Now that 3 pages get legitimacy. Though the accused who are here have no clue or idea regarding who these 6 persons are, what exactly the nature of this charge sheet is. Now when you look at this kind of a charge sheet, the impunity with which the charge sheets are framed and filed, in fact, whether it is Bhima Koregaon case or any other case for that matter, we see this kind of want of accountability, want of investigation. There is hardly an investigation which goes in great number of cases. Now, we are talking about these processes related to law, but we also need to look into the kind of prosecution that takes place. The very basis of prosecution itself is on a false claim. It is predominantly a manufactured kind of situation. What Nitya said regarding Delhi raid case or Bhima Koregaon case are only a small example of the same. There are millions of cases filed across the country in all the police stations. You come across this situation. You see this, that there is the degree of impunity with which the state operates, want of accountability in the administration, want of accountability in investigation. So that's one of the major issues. We have to look into those aspects. If there were to be a proper, honest investigation in cases, there is no necessity for this law. When you look at the last 70 years, do we mean to say that in last 70 years, we have failed as citizen of this country? In last 70 plus years, do we mean to say that except voting for elections, beyond that, we have not improved in our intellect or understanding related to citizenship is concerned? Now, if you were to look into the laws that have happened in the last year, that would be the same understanding you would come down to, that we have not been functioning as citizens. So therefore, when you look into from that construct, protest becomes a necessity. It is an expression through which you demonstrate that I am a citizen. An expression through which I demonstrate that I question this. It's an expression through which, though the state has this kind of methods that is employed to restrict the freedom of expression and restricting the very protest itself, I see that these are the possibilities. There are no other options out there. So therefore, when you talk in terms of any of the laws or modifications regarding the same, we need to look into the failure of the state in accountability and impunity of the state of abuse of this particular law. I think unless we talk those 2 aspects, talking on the finer aspects of a law, whether it is proper or improper, or can there be a modification? No, that goes to show that you are sanctifying all those illegalities that have been committed by the state. And that's something which we look into.
So are there any other questions unanswered?
Yeah, Aditya, are there any questions unanswered, or we can now go further?
Yes, so there is one question.
Okay.
the question is that can we establish a clear test to differentiate between free and fair criticism of the government and sedition? And how can we ensure that the ruling government does not misuse the provision of sedition to dissent? That's the question. That can there be a clear test which can be laid down?
Nitya, you want to go? Yeah.
Can we wrap this up? Yeah, I think. See, the whole,
Nitya, ma'am.
I think it's like Sita Ram ki kaun lagti hai, because the whole conversation has been that the difficulty of laying down these tests, and in spite of these tests being laid down, they're being observed only in the breach. Or if by the time, as Mihir said, you establish these principles, a man has spent time in jail, that is really the problem. So as lawyers, you must understand that there are overall parameters. But if what is at stake is expression, and what they're likely to lose is liberty, the question is whether it is worthwhile. That's all. For instance, a law like murder, there may be false prosecutions for murder, but you can't really do away with that section. But sedition, first, conceptually is wrong. Then the attempt to refine it has been observed more in the breach. Then the nature of sentiment proliferates in other laws. Therefore, now to ask, can we have further refinement? I would feel is somewhat missing the point. I'm sorry.
Last expression I would like to make after this Nitya madam's comment, Sitaram ki kaun hai? I would say, which is specifically mentioned in the Supreme Court's judgment, after telling all those things and condemned by the Supreme Court, not only to the prosecution, but then lower judiciary as well. And then top of it, people are not applying and then going with the same spirit. It lies the answer, I think, instead of saying then much. Because बताने के बाद भी कुछ नहीं होता है.
नहीं, मैं इनकी सवाल को कह रही थी.
Yes, I think we have taken all the questions.
एक सवाल है, आप जवाब दे दीजिए. Somebody is asking, should we not be more tolerant to the government? I think you are best fit to answer that question. One of the questions.
I cannot disagree on this aspect with you.
Mihir, you answer that question.
About what? Should we not be?
There's one question, should we learn to be more tolerant? If we go on talking about liberty, we are talking about being tolerant towards you, should we not be tolerant towards the government? ये सवाल है, किसी ने पूछा. I think the young person should be replied to.
I think we are more than, we are much more tolerant than required vis-a-vis the government. I think, and I'm again, as I'm saying, and I'm talking about all across governments. I'm not only talking about this government, but across government. We are much more tolerant than required. We meekly submit to various things that the government does without raising any kind of protest. We accept whatever they say. That has been the tradition, and we need to break that tradition. We need to support those who are trying to break that tradition. That's how I would look at it.
Yeah. Thank you so much. I suppose celebrating means when we're talking about commemorating the death centenary of Lokmanya Tilak, and the present government started the commemoration on the 1st of August, and also with his contribution to freedom struggle, we thought that one of the important thing what Tilak stood for is his freedom of expression, and that is what Nitya madam has been emphasizing in this 2 hours talk, that we should have a freedom to express ourselves, and therefore not about only sedition law, but all those legislations to take away my freedom should be struck down. So the tribute to Tilak would be that we should do away these laws against which Lokmanya Tilak did fought about, against which Tilak fought with, and that is what
that is too general. That is too general. He has some very obnoxious views on women. So everything he fought against, I'm not.
No, I'm not on his opinion. What he spoke on consent bill. No. We were talking about the political aspect of Lokmanya Tilak. What he did, the sedition aspect again. So why we should ask this government that if you are really serious about paying tribute to Tilak, why don't we do away with the legislations under which he was being prosecuted? So this is what we if you listen all the 4 speakers, they have been emphasize on the law being misused and then come to a conclusion that any refining the law will not help, because the state will still be misusing it. Therefore, philosophically, ideologically, this law should not be in place. And this is the message, I suppose, what this webinar will take about will give you. Now, I formally thank Mihir Desai sir, Nitya Ramakrishna madam, Venkatesh sir, and Santosh Jaybhay sir for participating in the discussion. And I hand over to my student presenter, Tanvi, to formally propose the vote of thanks.
Thank you, sir. Well, as the webinar comes to an end today, I must extend a vote of thanks and express my gratitude on behalf of Criminal Law Cell at ILS Law College, Pune, to all the speakers. Firstly, to Nitya ma'am for her eloquent analysis of the Tilak trials and for giving us the present-day scenario of the sedition laws in India today. Secondly, B.T. Venkatesh sir for enlightening us on the philosophy of sedition and for giving us a deep understanding of the same. Thirdly, to Desai sir.
Not thirdly, last but not least, you must say. Not thirdly.
Right, ma'am.
Not thirdly, you must say last but not least. Mihir.
Nitya, we have a fourth speaker. So that will be last, yeah. So
Yeah, that will be last. Yeah.
that is how it will be.
Not
Yeah.
thirdly. Mihir can never be thirdly.
Okay. Please go ahead, Tanvi.
Thank you, Mihir Desai sir, for enlightening us on the Kedarnath judgment and for giving us the judicial developments that came thereafter. And fourthly, to Santosh Jaybhay sir, our vice principal, for giving us his take on sedition and treason. This webinar today would not have been possible without our beloved faculty in charge, Dr. Nitish Nawsagaray, who has moderated this webinar so beautifully today, and Dr. Sanjay Jain, our acting principal, to whom we owe the smooth running of this event. I must also extend a vote of thanks to our promotional partners, Bar and Bench, Law Octopus, and Latest Laws. With that, I, Tanvi Mati, student coordinator at Criminal Law Cell, Pune, I'm signing off. Thank you, everyone.
Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you so much, Venkatesh sir. Yeah.